Hello, I am Carla Gunnan. I am with the law firm of Jackson Lewis. We do labor and employment law for management side employers. I am here today with Pro Bono Partnership Atlanta to present on the topic of OSHA. A little bit about Pro Bono Partnership of Atlanta. The mission statement of the organization is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. To be eligible for participation in Pro Bono Partnership of Atlanta, you must be a 501c3 nonprofit, be located to serve in the greater Atlanta area, serve low-income or disadvantaged individuals, and be unable to afford legal services. You're welcome to visit on the web. The website address is on the slide, and there are free monthly webinars on a variety of legal topics for your review. These are general guidelines, and it is not to be construed as legal advice. Please always consult an attorney to address your particular situation. Please do not copy, disseminate, distribute, or publicize this without written permission of Pro Bono Partnership of Atlanta. What is OSHA? OSHA is the Occupational Safety and Health Act that was passed in 1970. It established the Occupational Safety and Health Agency. This agency is commonly referred to as OSHA and falls under the U.S. Department of Labor. It is headed by the Secretary of Labor and is one of the many agencies within the Department of Labor. When the act was passed, it allowed for states to opt out of coverage by federal OSHA and to enact their own state plan. That is not something you have to worry about in Georgia. Georgia is part of the federal plan and is under the federal plan of OSHA. It also established whistleblower protections for employees. So these are employees who complain about safety and health. They are protected from any kind of retaliation from the employer. And also there are rights for employers under the Act to appeal citations that they are given and to handle other things related to citations issued to them. Turning to the Act, there are several portions of the Act itself, but one that is important to know as a nonprofit is that there are two parts to the Act that can require compliance on your part. Something else to be aware of is that the Act did not exempt nonprofits from coverage. So even though you are a nonprofit, you are required to comply with regulations promulgated pursuant to the Act or the General Duty Clause. So looking at the first bullet point, this is what is sometimes referred to as the General Duty Clause or Section 5A1 of the Occupational Safety and Health Act. This is just a general admonition that all employers are required to provide a healthy and safe workplace for all of their employees that are free from recognized hazards that are likely to cause death or serious physical harm. It is not required that death or serious physical harm have occurred before you get cited under this portion of the Act. The second bullet point refers to Section 5A2 of the Act, or all of the regulations that have been promulgated as a result of the passage of the Act itself. Turning to some of the regulations that could be of interest to nonprofit organizations. Lockout tagout. This is the requirement that if you're going to do servicing or maintenance on any piece of equipment, you're required to lock that machine out so that your employees are not potentially exposed to hazardous energy. Machine guarding. If your employees remove a machine guard, you could be liable under the OSHA Act for having allowed the employee to remove the guard and work with the machine without proper guarding. Respiratory protection. If you work in an industry that exposes employees to the potential for respiratory hazards, you want to make sure that you allow your employees and require them to use respiratory protection. Hazardous communication requires that if employees are using hazardous chemicals, they must be trained on the scope of that particular standard. You're also required to maintain something that's called a safety data sheet. It was once referred to as a material safety data sheet, but through some updates to the regulation, it is now referred to as an SDS, or otherwise known as the safety data sheet. Hazardous communication can apply to a nonprofit even if employees are using common everyday chemicals such as Clorox cleanup or Pine Sol. And that is because for those chemicals, they are considered to be hazardous chemicals. There is an exemption if those chemicals are used as a consumer would. However, if you have an employee who is, for instance, cleaning a bathroom frequently and cleaning it regularly to maintain sanitation requirements, then that's unlikely to be an exemption under the consumer products exemption, because that would be more than the consumer typically would do that type of cleaning activity. So hazardous communication is something to be very familiar with and is likely to apply to your business. Personal protective equipment is another regulation to be familiar with. Personal protection requires hearing protection, possibly if you have employees exposed to noise levels, or you could be required to provide goggles for employees who are exposed to hazards related to eye issues. The general duty clause can be the clause that requires you to do something that you know is a hazard to your employees, but there is no regulation that specifically applies. So be aware if there is something that you think creates a safety or health hazard to your employees, you may still be required to do something to protect your employees, even if a specific regulation has not been promulgated that requires you to do so. A little bit about the overview of the OSHA process. When OSHA shows up at an employer's work site, they have to be there for a specific reason. OSHA cannot just randomly show up. There are a variety of reasons why they may show up. For a nonprofit, it is unlikely that you will be the subject of a site-specific targeting inspection. This is the first bullet point, the SST. Those are related to employers who have high-hazard industries and lots of employee injuries or illnesses. What is a likely chance for an inspection for a nonprofit would be a complaint. We'll talk a little bit more about complaints later. There also are national emphasis programs. For instance, there's a national emphasis program on amputations. So if you have amputation hazards in your workplace, you could be subject to an OSHA inspection. Other things like referrals, these can come from the media. This can come from a compliance officer who becomes aware of hazards at your workplace. They can self-refer. And other agencies can also refer OSHA to health and safety hazards in the workplace. If you have a fatality or hospitalization, you are required to report that to OSHA. You're required to report a fatality within 8 hours of the fatality, and you are required to report hospitalizations of one employee within 24 hours of the hospitalization. There is also a new requirement that employers report any amputations that occur in the workplace within 24 hours of the amputation. When OSHA shows up, there are certain things that happen. The first thing that they will do is have an opening conference. The opening conference is when they tell you why they're there, what the scope of the inspection is likely to be, and what they plan to do during the scope of the inspection. You can ask questions of OSHA, and you can inquire as to why they are there. And if they are there on a complaint, you can take them just to the specific complaint area. That will be part of the walk around, taking them to the complaint. The walk around just simply consists of OSHA walking around your facility. This does not mean that you necessarily have to take them through a tour of your facility, but you take them through the particular areas of the facility where complaint items are, or referral items are, or if there's a national emphasis program related to amputations, you take them to those issues. After OSHA has completed its inspection, they will have a closing conference with you as the employer, and they will tell you what they have found to be hazards at the work site and any citations that are likely to issue. They have 6 months from the opening to the conclusion of their inspection. The next slide demonstrates some of the frequently cited OSHA standards for the time period October 2011 to September 2012. We're going to flip to the next slide, and this is the time period October 2013 to September 2014. And if you did a comparison of those two slides, you will find that it is virtually identical. I emphasize this to let you know that what are the big issues and most frequently cited issues by OSHA typically doesn't change from year to year. So you as an employer can know what is OSHA likely to look at if they were to come to my work site. And looking at this next slide, It's very important that you know your NCAIS code. This is the newer version of the Standard Industrial Classification Code. Every employer falls into a specific industrial classification, and this system is what OSHA looks at to accumulate data. You can find out what your industry falls in the specific code by simply going on to OSHA.gov, clicking on the Data and Statistics tab, and then looking up your code. If you do not know your code, this will take you to another website where you can look up your code. The reason why you want to know this is because once you know your code, you can type in your specific industrial classification code and learn what are the top frequently cited standards for your specific industry. That way you know what the template is if OSHA comes in. You'll know what specific regulations you should look to so that you are ensuring that you are compliant with OSHA regulations. Complaint-based inspections comprise approximately 20% of all OSHA inspections. So if you think about that, that's a fifth of all the OSHA inspections are generated by complaints from your employees. Employees have an easy time to log a complaint. They can go on the computer and simply log a complaint online. So be very mindful of complaints that your employees may bring to you internally. In fact, you want to encourage your employees to bring any safety and health concerns to you first. Typically, employees who become frustrated are the ones that then decide it's best to just contact the agency because the employer doesn't care about safety and health issues in the workplace. So to a large degree, you can manage complaint inspections by managing your workforce and the expectations about health and safety. Labor unrest in a workplace can generate complaints, and the Government Accountability Office has done a study to indicate that. That's referenced here at the bottom of the slide. So bear in mind, employee complaints are important. You want to hear first, and you want to work through those before they go to the agency. Some tips for handling complaints are to review the procedures that you have for employees raising health and safety concerns. Let employees know that you are concerned of their health and safety, and if they have any concerns, that they need to come to you and that you'll work together to try to take care of the concerns that they have. Look at your work orders. If you have work orders outstanding for replacing machine guards or ordering personal protective equipment or other such things, make sure you've got that in a work order system so that you can get those ordered and provide those to the employees. Survey your employees, talk to them, ask them how they feel about the safety in the workplace, and listen to those concerns and address them. Even if your employees have a concern that you clearly do not think is an actual concern, you should still listen to them and then explain to them that it is not a safety concern and here's why. And you can even point them to why it's not and explain some things to them. And certainly if you have any accident or near misses, you want to investigate those so that you can be prepared with your employees for what is happening in the workplace. So some things to do to prepare for an inspection. And you never know when you're going to get an OSHA inspection. It's actually illegal for OSHA to tell an employer prior to coming to the work site that they are coming. So it can be a just show up and here I am, I'm OSHA. First impressions are important. You want to make sure that you have neat and orderly work areas. I have for many years heard that OSHA inspectors are put off by unkempt, disorderly workplaces. They feel like that in itself presents a safety hazard. And there is actually a regulation that requires you to maintain good housekeeping in your workplace. So make sure you have that in order before OSHA shows up. Train your receptionist, if you have a security officer, whoever is the person who greets the people first when they come in your door, make sure they know what to do. You want to make sure that they understand that when OSHA shows up, that doesn't mean that they just have to allow OSHA to walk around. Make sure a manager is involved and that there is one point person who is having communications with OSHA and organizing what OSHA wants and the requests that OSHA may make. Plan for the opening conference, who will attend, the participants, train people about what that means. And remember that even the first line supervisor is equivalent to the head of your organization. They sit the same in OSHA's mind. So if your frontline supervisor tells OSHA something that perhaps may not be accurate, then that can hold you responsible for knowledge of safety and health hazards in your workplace. So ensure that those people, especially your frontline supervisors, have someone at a higher level of management sitting in with them for any OSHA interviews. Make sure you have any compliance records together. If you're required to do training under specific standards, make sure you have those records ready and available to show OSHA if they should ask for those. If you are required to maintain OSHA 300 logs, then make sure you have those ready and available as well. You only have 4 hours to show OSHA 300 logs to OSHA once they ask for copies of your logs. OSHA record keeping is a very complex topic, and we will not get into a lot of that in this session. But if you are required to keep those records, you can check to see, first of all, if you are in industry required to keep those records. And if you are, just make sure that you are following the regulations for OSHA record keeping. If you have any type of audits that have been offered by insurance companies or the like, make sure that you have no open items. Make sure there hasn't been a suggestion that you do need to do some additional machine guarding, or maybe you do need to add personal protective equipment, or other things that you could have done but you haven't done, and you've just filed that audit away in a drawer, because those can be problems for you in the future. Make sure you have a system for closing out any suggestions offered by audits. Again, on complaints, have a reporting system for your employees to complain to you first, and ensure that safety rules are followed. There is a defense under the Occupational Safety and Health Act to a citation called the employee misconduct defense. But in order for that defense to work, you must have a work rule. You must train your employees to follow that work rule. You must monitor the employees to ensure that they are following the work rule. And lastly, you must supervise and monitor, not 24/7, there's no requirement for that, but you must do some type of monitoring to ensure compliance. If you should get an OSHA citation, there are 6 types of OSHA violations that can be levied. For nonprofits, the ones that are more likely are other than serious or serious. Unless you've had a prior OSHA inspection, you would not be subject to a repeat, and you would know clearly if you'd had a prior OSHA inspection. Willfuls are also a higher level that typically requires that the employer had a heightened awareness of a standard or a requirement, and that they were willfully not following that. Willful is defined as you're plainly indifferent, or you're disregarding the requirements of the regulation. Typically, for the other than serious, even though it can be up to a $7,000 penalty, the penalties are far less, and many times are $0 penalties. Serious can have up to a $7,000, but again, are oftentimes less than that. As a small nonprofit, you would be eligible for significant penalty reductions based upon size. If you have no history, no OSHA inspection history, you get some penalty reductions as well. So even from the original penalty, OSHA will calculate a revised lower penalty based upon size and history and good faith. If you cooperate during the inspection, you get credit for that as well. There are 2 last violations. There's a failure to abate and criminal sanctions, not something that typically applies to a nonprofit organization. There have been some very large fines, and perhaps you have seen these in the press. BP Oil was the most famous of the large fines. They had the largest fine ever in OSHA history, over $150 million total in fines to BP Oil. And sometimes people ask, how is that possible? Because the fine structure just doesn't seem to get to $150 million. OSHA does have something called the egregious policy. It typically applies to standards that are personal in nature, such as fall protection requirements. And you can see from this slide in the example of fall protection, if you have several employees exposed to fall protection hazards and they are not, you're not requiring compliance, then you could be subject to a very significant fine from OSHA. People have wondered if that's really allowed. It is allowed. This is a very busy looking slide, but it basically tells the history of how this has gone up to high-level appellate courts about the egregious policy that OSHA has issued. And the appellate courts have always upheld that the egregious policy does apply and can be used. So OSHA does have a live and viable egregious policy. One more reminder, make sure you know what regulations you need to comply with and follow them. After you receive a citation, you do have rights. You have 15 days to contest the citation or request an informal conference. Many times, an informal conference is a very helpful way to resolve a citation without the citation moving into a more formal litigation type of process. The informal conference is very easily done. It's simply calling the OSHA office, scheduling that with one of the supervisors in the office, and they will meet with you to hear your concerns about the citation. The supervisor who meets with you can do several things with the citation. They can choose to withdraw the citation if you have evidence and facts that support that, or they can lower the penalty further and possibly change classifications and those types of things. It's a lot of value to go to an informal conference. Many times with the OSHA citations, you will see that there is an expedited informal settlement agreement that gives you a penalty reduction just for signing that agreement. But sometimes it's better to go meet face-to-face and have the dialogue and see if there's other options for you, especially as a nonprofit. There are ways that OSHA can extend payment penalties over time and those types of things. So something to think about and consider if you should receive a citation. If you still feel the citation is incorrect, within that same 15-day working time period, you can file a notice of contest. The notice of contest would make the citation go to a different path, and it's the same track for the 15 working days, so you must do those simultaneously. And typically you're having that dialogue with the supervisor in the OSHA office. I referenced some other states here. No need to worry about that in Georgia. Just bear in mind that the 15 working day time period is a hard and fast date. If you miss that, then your citation will be deemed a final order, not reviewable by any court or agency. After a contest of a citation, and again, this is not a very difficult task. A contest is merely a letter stating that you contest the citation, the abatement dates in the citation, the penalties in the citation, and that you want further review. At that point, OSHA will turn the case over to an agency called the Office of the Solicitor, often referred to as SOL. And these are the attorneys that handle the cases for the U.S. Department of Labor. Those attorneys will also engage in a process to try to settle the case with you as well. If you cannot reach a resolution, then OSHA has the burden of proof on all elements in the citation, and they would have to go before a judge to prove their case. You would also have an opportunity to prove any affirmative defenses that you might have to the OSHA citation. We mentioned previously the employee misconduct defense. That is an affirmative defense that you would be permitted to present before a judge. The ALJ is the administrative law judge, works for the Occupational Safety and Health Review Commission. This is a separate agency. It is not part of OSHA, nor is it part of the U.S. Department of Labor. It is an independent agency that was established in order to hear OSHA contested cases. After an ALJ issues a decision, the decisions are then reviewed by the Occupational Safety and Health Review Commission in Washington, D.C. And after that, there are further reviews that can be taken to appellate courts and ultimately the U.S. Supreme Court. Not often do OSHA cases go to the U.S. Supreme Court, but there have been a handful in history that have. Something else to mention that may be of importance for a nonprofit are the use of temporary workers. OSHA has been very uncertain about employers' use of temporary workers, because what they have found is that this industry has grown significantly since 1990, and employers are using temporary workers more and more. So as a result, OSHA issued an initiative in April of 2013 on temporary workers. Now, OSHA's policy about temporary workers has not changed. OSHA has always had the opinion that if you have a temporary worker working side by side an employee who is working in your workplace, that the temporary worker is entitled to the same safety and health protections as your employee, as well as any training on any hazards in the workplace. So it's important to know that if you're getting temporary employees, whether you get them through a staffing agency or even if you just hire temporary employees seasonally or however you might do that, that you want to make sure that they are trained to the same level of your employees that are working for you more regularly. That would include data gathering, best practices, anything you do that would be important for the employee. If you are using a staffing agency, bear in mind that OSHA thinks that there is a joint responsibility between the staffing agency and the employer with regard to the health and safety of the employees, and that there is an expectation that you have that dialogue with the staffing agency to understand who will be training, who will be supervising, and who will be logging any injuries that the employee may suffer. Some best practices that OSHA has put out in their initiative is that you should have a written safety and health program, perform a hazard assessment of the work site, define the scope of work in the contract, conduct new project orientation and safety training that addresses hazards that may be that temporary workers may be exposed to, and to maintain communication with the workers and each other. Lastly, OSHA has also issued some guidance in terms of record keeping. If you're an employer who does not have to keep OSHA records, then you do not have to worry about this. However, if you keep OSHA logs for your own employees, bear in mind that you may also have to log the injuries or illnesses of temporary workers as well. And this will all be looked at according to who supervises. And if you supervise day to day, the details, means, methods, and processes by which the work is to be accomplished, then you're going to be deemed to be the employer, not the staffing agency. So even if the staffing agency actually pays the employee and handles all of the issues related to taxes and those types of concerns, or workers' comp, OSHA would still deem you to be the employer if you are doing the day-to-day supervision. So bear that in mind. And that's the end of our presentation. If you have more information about the services of Provo Partnership of Atlanta, please log in to www.pbpatl.org or phone 404-407-5088. And at this time, I will see if there are any questions from any of the participants today.
Well, and I have a question for you while people are thinking about what their questions are, and that is, Carly, you described a lot of steps in the process, from inspection to a citation being issued to the contest of the citation. At what point should you consult with an attorney to help you address these issues if they come up with OSHA?
Yes, and so at any time in the process, it can be appropriate to consult with an attorney. I have clients that consult with me during the OSHA inspection process because they are unsure about the scope of what OSHA is required to do or what they're permitted to do. And that may be the time that it is logical for you to do it. It could be that OSHA shows up and they're gone within a few hours. And so there is no time to consult an attorney. And after that time, you may want to consult the attorney to ask what happens next. And certainly at the time you receive a citation, that's always a good time to consult an attorney, because it's good to know what are your affirmative defenses and to have someone who has a little bit more knowledge about the area that you can talk to find out, is this something I should contest? Should I go to the informal? What are the next steps that would be most appropriate for my organization?